Further hearing in a reference by the Attorney General and the Advocate General for Scotland in UK withdrawal from the European Union, legal continuity, Scotland Bill.
Yes,
My lady, my lords. I'll just pick up on a couple of things from yesterday. I should have said at the outset that I adopt my written case in its entirety, subject to these submissions, lest I don't cover everything I would like to cover in the course of today.
it's always very sensible to say that.
Indeed, and...
Otherwise you may get stuck with somebody saying he didn't press it in oral argument.
Well, I do adopt the entire case, and there's lots of people behind me have contributed to it.
Absolutely, thank you. Yes.
And I also invite the court to read the policy memorandum as a whole when considering the purpose of the bill. The short statement which deals with the point that my Lord Sumption raised with me yesterday is an observation of my Lord Reid in the AXA case at paragraph 145, where he, in the course of a analysis of the nature of the legislative powers of the Scottish Parliament. This is at MS 899.
Which paragraph, Mr.
It's in paragraph 145,
Thank you.
the last sentence of that paragraph. My Lord Reid observes they, acts of the Scottish Parliament, can amend or repeal acts of the UK Parliament so far as applying to Scotland. And he then goes on to elucidate the plenary legislative power of the Scottish Parliament.
Yes, the last sentence is really implicit in Schedule 4.
Indeed, my Lord. Yeah. Indeed. And I should say, the fact that there are two legislatures with overlapping competencies for Scotland usually causes no difficulty for two reasons. First of all, because the UK Parliament normally legislates in non-reserved matters only with the consent of the Scottish Parliament. And Parliament tells us that in section 28, subsection 8 of the Scotland Act. And it's a matter of routine working of the Constitution that proposals to legislate at Westminster for Scotland which might engage the Convention are considered by lawyers for both governments to consider whether or not consent is required, and if it is, then it's invariably sought. And if consent is refused, then changes will be made to bills in order to address the issues or to remove the need for the consent to arise, either by removing Scotland from the scope of the bill or non-reserved matters from the scope of the bill, leaving it for the Scottish Parliament to deal with the matter. So if there are parallel proposals to legislate on the same matter in the two legislatures, that will normally, and until this instance, invariably has been resolved by the normal working of constitutional convention.
This situation has never arisen before, is that right?
No, this is the first time that the UK this UK Act is the first act which the UK government acknowledges engages the Convention and which it has passed, notwithstanding that the Scottish Parliament refused its consent.
Was consent sought?
Yes.
Yes.
And in my case, I give the references in the explanatory notes to the UK bill, which disclosed that the UK government accepts that consent was required. And consent was refused by a significant majority in the Scottish Parliament. And in that sense, my Lord's assumption is correct, that in non-reserved matters, Westminster legislates with the consent of the Scottish Parliament, not only in the sense that the Scottish Parliament can repeal or amend non-reserved acts of the UK Parliament, but in this more fundamental constitutional sense. And to that extent, as a matter of description, as a matter of constitutionality, if not as a matter of juridical analysis, there is force in Lord Hope's observation in Jackson that the sovereignty of the UK Parliament is no longer absolute. And that's paragraph 104 at MS 3200. The second reason why this doesn't cause difficulty normally, my lord, is that if one of the parliaments amends legislation of the other, it does so by express provision drafted by skilled parliamentary counsel of the sort with which, as lawyers, we are familiar. And the issue with which the court is faced if the Advocate General's submission is correct on the interaction between the two enactments is likewise an unprecedented one. With those remarks, perhaps I can return to section 17, returning to the main flow of my submissions. Section 17 of the bill is at MS 227. And the court will recall that my learned friend, the Advocate General, takes issue with this on the basis that it modifies sections 27 or section 63 of the Scotland Act, or relates to the reserved matter of the Parliament of the UK. And in answer to those submissions, perhaps I could make these observations. First of all, this is a provision that applies only to subordinate legislation. That's in section 17.1. Secondly, it's concerned only with subordinate legislation which contains devolved provision, and that's section 17.1a. And devolved provision is defined in 17.4 to mean provision that would be, if it were contained in an act of the Scottish Parliament, within the legislative competence of that Parliament. And we're concerned only with such subordinate legislation made by a minister of the Crown. And I say this provision, which requires the consent of the Scottish Government for such provision, reflects the allocation of responsibilities which is inherent in the Scotland Act. Ministers of the Crown, as a general rule, have no policy responsibilities in Scotland in relation to matters which are within the legislative competence of the Scottish Parliament. Executive competence was transferred to the Scottish ministers in section 53 of the Scotland Act. So justice as a generality is not reserved, and the Scottish ministers have the policy responsibility accountable to the Scottish Parliament for justice matters. And section 17 ensures that the Scottish Parliament can ultimately control whether legislation in matters which are within its own competence, section 17.4, will take effect in Scotland. And one looks at this in a context where the Scottish Parliament may amend or repeal an act of the UK Parliament in non-reserved matters, where it may amend or repeal any subordinate legislation by a Minister of the Crown in relation to non-reserved matters, where it may legislate to confer functions on or to remove functions from a Minister of the Crown. And that's a possibility that's expressly envisaged in Devolution Guidance Note 15, which the court has at MS 3760.
3760. Thank you.
And in my submission in that context, it's plain that the Scottish Parliament may legislate to regulate the exercise of functions by ministers of the Crown within devolved competence, within the legislative competence of the Scottish Parliament. But of course, in a sense, a proposition that this fits or doesn't fit with the general allocation of responsibility, which I say it does, ultimately doesn't answer the question of whether this modifies section 27 or section 3 of the Scotland Act. Sorry, 28.7 or section 63.1 of the Scotland Act. Perhaps this might be a convenient moment to make a short submission about the meaning of the word modify, where we find it in Schedule 4. The technique adopted in Schedule 4 to protect certain enactments from modification is quite different from that adopted in relation to reserved matters in Schedule 5. I say the inclusion of an enactment in Schedule 4, Para 1 of Schedule 4, does not create a reserved field. It's quite possible for the UK Parliament to reserve the subject matter of an act, and it does that at many places in Schedule 5. That reserves the field, the subject matter of the act. But when the UK Parliament includes an act in Schedule 4, it protects it. It doesn't create a reserved field. It protects the enactment from modification. And indeed, where Schedule 4 protects the effect of an enactment and not merely the enactment itself, that is expressly stated. And the court can see that at paragraph 2, sub 3e, and para 5a at MS 542 and 546. So there's a structural difference of approach to be taken. Modify is defined to include amend or repeal, section 126 at MS 515. In Imperial Tobacco, at paragraph 44, MS 924, Lord Hope observed that the sections under consideration there do not seek to amend or otherwise affect the protected enactment. And in my submission, that can't be taken as an authority for the proposition that any provision which affects a protected enactment thereby modifies it. And I refer in my case at paragraph 84, MS 141, to the approach which was taken by the judges in the Inner House in Imperial Tobacco, and also by Lord Doherty at first instance in the Scotch whisky case, which in my submission support two propositions. That a provision which does not alter a provision in a protected enactment, but adds further provision, albeit in the same field of law, is not a modification. And that was an observation of the Lord President in Imperial Tobacco. And secondly, that if the protected enactment continues in force as before, it has not been modified.
So your submission is that modification means a repeal or a textual alteration?
Yes, and I accept...
And nothing more?
Subject to this, that I accept that one may have a modification that arises not by virtue of a deliberate provision that says the section whatever of the Act is hereby amended.
Yes.
I accept that a repeal or amendment may not be express, that there may be such an inconsistency between the two provisions, or that a provision under consideration may so frustrate the effect of a provision in the protected enactment that it becomes a dead letter, or that the two...
So if an act of the UK Parliament provided that certain rules were to apply in Scotland, and an act of the Scottish Parliament said that they were not to apply in Scotland, that the latter provision would be incompetent, would it?
That would be a modification. If the former was a protected enactment, if the former was a protected enactment.
Yes.
And that's why I accept that certain, if we get to the question of modification, I accept that certain provisions in the Scottish Bill would amount to modifications.
But I don't think you accept that in relation to Section 17.
I don't, no.
But if the effect of the original enactment remains intact, then you say there's no question.
There's no modification. Indeed. It's a different sort of protection from the protection of a field of legislative activity.
It's difficult to say that its effect remains intact if you add a condition, if you make its effect conditional on something which is not a condition of the original provision.
Yes.
Then it's not intact, I suppose.
Yes. Can I say it's perhaps important to, I'm conscious that my Lords may be anticipating the broader question of the interaction between the two acts. At this point, I'm simply looking at section 17.
Yes, well, I was
the
thinking
question
of
of whether it modifies section
thinking of section
28.7 and 63.1, which is the specific point that's taken. And on the interaction, as my learned friend, the Advocate General, pointed out, Section 17 can't apply now to the UK Act, simply because the UK Act has been enacted ahead of Section 17, and Section 17 in terms only applies to subsequent enactments. I say in relation to the question of whether Section 17 modifies Section 28.7, the power of the UK Parliament to legislate for Scotland, I make a very short point that Section 17 doesn't alter at all the power of the UK Parliament to legislate for Scotland, and nor could it. And I adopt my case at MS 143. It's open to the UK Parliament as a matter of law, subject to the Legislative Consent Convention, to legislate to repeal Section 17 or to disapply it from any particular enactment. And it's open to the UK Parliament to protect such a provision from any further amendment by the Scottish Parliament.
The sort of bootstraps element of this. I mean, if it's not law, there's no need to repeal it. I mean, the possibility of its being repealed, it doesn't really answer the question whether it's law or not.
Yes, but indeed, my Lord, but the grounds on which it's said that Section 17 is not law are, firstly, leaving aside the effect of the UK Act, which I'll deal with, if I may, deal with discreetly at the end of my submission. The grounds on which it's said that Section 17 was not within the competence of the Scottish Parliament when it passed it is that it is said to modify, first of all, modify the power of the UK Parliament to legislate for Scotland. And I say it doesn't and can't. It's said that it modifies Section 63.1 of the Scotland Act, and it said it's said to relate to the reserved matter of the power of the Parliament of the UK. Section 63.1 is at MS 451.
But before we leave Section 28.7, do you accept that the power of the UK Parliament to make laws for Scotland includes the power to delegate to UK ministers the power to legislate and lay down the procedures by which they do so?
I accept that's indeed.
Yes. Well, would imposing a further hurdle on that delegated legislation becoming law in Scotland not be a modification of Section 28.7?
In my submission, not, my Lord, because
Why not?
And it's very important to keep in mind that Section 17 applies only to subordinate legislation within the legislative competence of the Scottish Parliament. So the Scottish Parliament which would have the power to repeal or amend a provision of the UK Parliament delegating powers to ministers within its competence, would have the power to repeal or amend such subordinate legislation, in my submission, clearly also has the power to create a provision such as this. The UK Parliament always has the power to override that, either by, say, itself amending or repealing Section 17, or by saying that it doesn't apply to a particular enactment.
But it's one thing to make laws. It's another thing to repeal laws once made.
Or to say that Section 17 doesn't apply.
Thank you.
Perhaps one thinks about it this way. If I accept the UK Parliament may exercise its legislative power to give powers to ministers of the Crown, and to do so in relation to matters within the competence of the Scottish Parliament. It would then be open to the Scottish Parliament, for the reasons we discussed a moment ago, to repeal that provision.
But until repealed, it would be law.
It would be law.
Under this provision, it would never be law without the prior consent of the Scottish ministers.
Indeed.
Well, isn't that a modification of section 28.7?
Well, in my submission, not, my lord.
It's only sort of ping-pong game.
Sorry, my lords.
I mean, we sort of go round in circles, and it's...
But your answer is, because we can repeal it, we can do what is in section...
I say it doesn't affect the power of the Scottish Parliament, the power of the UK Parliament to legislate for Scotland at all. It's simply an exercise by the Scottish Parliament of the powers that it has to legislate in relation to matters which are within its competence.
Not a pro tem modification.
In my submission, not. I say section 28.7 continues as it was before. The logic of the position taken that my Lord Hodge is postulating, if taken to an extreme, would be that if the would be to take one to a position where the Scottish Parliament can't repeal an act of the UK Parliament, because that's to interfere with the power of the UK Parliament to legislate for Scotland.
I'm not sure if that is a logical consequence of what I was saying.
Well, I've made the submission is there, it's in the written case. My Lords and my Lady will consider it. As far as section 63.1 is concerned, this is the power under the Scotland Act at MS 451, under which functions may be either transferred to Scottish ministers or stated to be exercisable by the Minister of the Crown only with the agreement of or after consultation with Scottish ministers by order in council. And again, I say that section 17 doesn't affect that power. Her Majesty continues to be free to exercise those powers as they stand. And typically, I entirely accept that they may be used in relation to non-reserved matters, but typically these powers have been used to transfer or to deal with reserved matters, which is why there is a special procedure under Part A.
But you can exercise the powers, but if they fall within the scope of section 17, the exercise of the power won't be of any effect without the consent of the Scottish Parliament.
No, that's not the point, my Lord. I think the point that my learned friend was making, if my Lord has section 63 at MS 451 in front of him, my Lord will see that what Her Majesty may do is provide for functions so far as exercisable by a Minister of the Crown to be exercisable by the Scottish ministers instead, or by the Scottish ministers concurrently, or by the Minister of the Crown only with the agreement of or after consultation with the Scottish ministers. And my understanding of my learned friend's point is that he contends that because there's a procedure in 63(1)(c), whereby a power of a Minister of the Crown may be exercisable only with consent, that excludes any other route to provide for consent, a consent requirement in relation to the exercise of such a power. And my short submission is that that simply doesn't follow, that the exercise of these powers is entirely unaffected by section 17. Section 17 and I'm rather wary of suggesting the logical consequence of any position, but a consequence of the view that section 63 was exclusive of any other provision would be that the Scottish Parliament couldn't provide in a particular case for a power of ministers of the Crown within the Scottish Parliament's competence to be exercisable only with consent. And in my submission, that simply couldn't be right. My learned friend also makes a submission that Section 17 relates to the reserved matter of the Parliament of the UK. And in my submission, that is incorrect. The purpose having regard to the effect of Section 17 is to regulate the exercise of powers to make subordinate legislation within the legislative competence of the Scottish Parliament. It doesn't affect the powers, memberships or privileges of the UK Parliament. Those are my submissions on Section 17. I wonder if I might turn to a group of submissions made by the Advocate General, which challenge a number of different parts of the bill on the footing that they anticipate the withdrawal of the UK from the European Union. He contends, firstly, that significant parts of the bill are incompatible with EU law, and for that reason, not within legislative competence on that ground. And those provisions are identified at paragraph 84 of his case, MS 71. And separately, that the provisions in relation to spent enactments are not within competence. And these are points he makes at MS 65 and following. And the two, although different issues arise and they're separate, ultimately different submissions, they raise similar issues regarding the question of whether the Parliament may legislate in anticipation of a future event. Can I say it's not a matter of dispute that the question of whether a provision in an Act of the Scottish Parliament is within the legislative competence of the Parliament requires to be undertaken before the Act comes into force. But my submission is that that does not mean that one ignores features of the scheme when assessing that question of competence, features of the scheme which deal with the problem of time. If one looks at the matter as a matter of generality, of course, legislation is often enacted with provisions to defer commencement for a number of reasons. The distinction between enactment and commencement is not a trivial one. It is the distinction between being on the statute book and being part of the law of the land. And that's, my Lord, read in RM, paragraph 22 at MS 3259. And in RM, my Lord observed that commencement is often deferred to allow persons affected to prepare for its practical operation. But there may be other good reasons to defer commencement. The Counsel General for Wales gives an example of the use of a deferred commencement as part of a scheme for transferring from one tax regime to another, and thereby to avoid a convention incompatibility. And that's at paragraph 14.4 of his case at MS 175. And in the context of an Act of the Scottish Parliament, it might be used to give time for the UK government to put in place an order under Section 104 of the Scotland Act to enable the Act to operate effectively. And it may be necessary to legislate in anticipation of some future event, including a change in the law. let's suppose EU legislation were passed to replace a previous legislative regime on a particular date, and that it requires domestic implementing legislation. It would be entirely sensible to enact the domestic implementing legislation in anticipation of the change, so that it will be in place on the date when the change takes place, but to defer commencement so that the two provisions to come into force at the same time. And in my submission, one could do that even if the terms of the domestic implementing legislation that are being enacted in anticipation would be incompatible or inconsistent with the EU law currently in force if they were to be brought into force at an earlier date. These are all perfectly practical possibilities, and in my submission it would be inconsistent with the nature of the legislative competence of the Scottish Parliament if it could not make practical use of commencement arrangements to deal with future events.
Well, it's not simply a question of practicality, is it? I mean, the objection put forward is that this is contrary to the supremacy of EU law. But if it only has any legal effect at a stage when EU law is not supreme, that would appear to be the end of the matter.
Well, if that's correct, my lord, and it's not lawful, it's incompatible with EU law to make provision in advance of withdrawal from
No,
the
I'm
EU,
making the opposite point.
that would affect the UK Act.
Indeed.
The UK is proceeding on this analysis. So the only question is whether, when one steps down to the Scottish Parliament, there's any reason why the Scottish Parliament can't make similarly.
The principle must be identical, whichever Parliament you're looking at, because this is not a comparison between what Scottish Parliament has done and an act of the UK Parliament, except
Indeed.
the European Communities Act.
Indeed.
It's a comparison with an entirely external source of law to which we have signed up, namely EU law.
Absolutely, my lord.
That equally applies to any legislative body.
Indeed, my lord. And of course, if it's correct that what the UK Parliament has done is incompatible with EU law, then then that's a consequence. But I simply make the point that the UK government is proceeding on the same analysis. My learned friend, the Advocate General, criticised the Scottish Parliament on the basis that it's legislating for a hypothesis. He said the Scottish Parliament is not a soothsayer. And my short answer to that is that it is not hypothetical that the UK will be leaving the European Union. We have given notification under Article 50, and in terms of that article, the treaties will cease to apply to the United Kingdom on the 29th of March next year, unless something happens to change that position. And it is not hypothetical that as a matter of law, for the reasons I discussed yesterday, that the EU constraints will then cease to have any bite so far as the Scottish Parliament is concerned. So this bill was enacted to deal with a known future event, which will take place not in the far distance, but relatively imminently, and which will have known consequences so far as the Scottish Parliament's legislative competence is concerned. So I could deal with the different provisions which my learned friend has attacked. In turn, if the court has his case at MS 30,
Right.
I beg the Lord's pardon, MS 71, paragraph 84, where he identifies provisions that he says are incompatible with EU law. And of course, that's the question. Is the provision incompatible with EU law, section 29(2)(c) of the Scotland Act? And I say that one can test whether a provision in an Act of the Scottish Parliament is incompatible with EU law by asking whether it puts the United Kingdom in breach of its obligations under the European Union treaties. That's the essential purpose of the provision, as recognised by this court in Miller. And I have produced cases which illustrate that EU law, like our own law, recognises the distinction between a provision being enacted and a provision being in force. Those are cases at tabs 9, volume 9, tabs 56 to 58, MS 3419 and following. I don't think it's necessary to take time with them. They're simply illustrative that the distinction is one which is recognised by European law. So if I look at the provisions that the Learned Advocate General attacks at paragraph 30 of his case, sections 3 to 5 and 13 are mentioned in paragraph 84, sub 1. Sections 3 to 5 in terms take effect only on and after exit day. That can be seen at MS 211 and MS 212. And in my submission, if one asks, is a provision that takes effect only on and after exit day incompatible with EU law? The answer is plainly not. One can't pretend that that qualification, that contingency is not built into the provision. And equally, section 13 applies only to EU legislation which has effect in EU law after exit day, which is defined in the Scottish Bill at section 28 as the day that the UK leaves the EU, and then further defined as when the treaties cease to apply as a consequence of withdrawal. And likewise, sections 6 to 8 and 10, which are mentioned in paragraph 2, all take in effect according to their terms only on or after exit day. Section 11, which is the next paragraph mentioned, is in a different category. Section 11 is at MS 217. And this is the power under the Scottish Bill to fix deficiencies in retained EU law. And the intention in relation to that power if the court has the provision, it's MS 217. It's a power where the Scottish ministers consider there is or would be a failure of retained devolved EU law to operate effectively or any other deficiency, and it's necessary to make provision to prevent or remedy that, then regulations may be made. And the phrase would be makes clear that it is anticipated that these are powers that will be exercised in advance of exit day, so that the body of retained EU law can be made ready for withdrawal by fixing parts of that body of law which will not operate effectively following withdrawal. But insofar as such regulations would, if brought into force, be incompatible with EU law before exit day, then they may not be brought into force before exit day under this Act. That's precisely the same structure as the United Kingdom Act has. And it's no part of my submission that the UK Act is incompatible with EU law. But I say the Scottish Parliament, the Scottish Bill, is not incompatible with EU law because it adopts for the reasons I'm outlining. I recognise that it's inherent in a fixing power of this sort that it will involve regulations being made, and because they are changing EU law, that if they were brought into force before withdrawal, that would be incompatible with EU law. But it's my submission that the deferral of the coming into force of such regulations until withdrawal means that they would not be incompatible. The power is capable of being exercised in that way. Therefore, the power is not incompatible with EU law. Perhaps I could just amplify the submission in this way. First of all, EU law envisages that a member state may withdraw from the EU. And in my submission, following notification by a member state of its intention to withdraw under Article 50, it is not incompatible with EU law for a member state to make provision with a view to the satisfactory and certain operation of its laws on and after withdrawal. Legal certainty and legal continuity, after all, are principles of EU law, and legislating to secure those principles in the context of withdrawal is, to put it no higher, permitted by EU law. The power in Section 11 is capable of being operated in a manner which is compatible with EU law. Ministers may be expected in regulations made under the power to specify which provisions take effect before exit day and which take effect after exit day. And they could not lawfully bring into effect before exit day provisions which would at that time be incompatible with EU law. And if they were to do that, then that provision would not be law. And if there is a dispute about whether ministers have got that right, that can be adjudicated on by the courts in the normal way. Section 1, subsection 3 of the Act at MS 1 subsection 2 provides that insofar as any provision of this Act or any provision made under it would, if it were in effect before the relevant time, be incompatible with EU law, the provision is to have no effect until the relevant time. And in my submission, that was not a necessary provision, essentially for the reasons I've just outlined, that the power would require to be exercised in a manner that was compatible with the supremacy of EU law. But there it is, and it puts the matter beyond doubt. So I say that for these reasons, none of these provisions are incompatible with EU law, and the further ones to which the Advocate General refers, I think, are simply consequential. He also challenges these provisions on the ground that they modify the effect of Section 2, subsection 1 of the European Communities Act 1972. And in my submission, the bill does not modify that provision. It neither purports to repeal nor to amend it, nor does it have an effect which is inconsistent with Section 2, subsection 1. As the Supreme Court held in Miller, Section 2, subsection 1 will be emptied of content upon withdrawal from the EU. And the intertemporal arguments apply equally here. Nothing can be done under the bill which would be incompatible with the rights and obligations arising under the treaties. Can I then just turn briefly to the provisions dealing with spent enactment, section 33 in Schedule 1 of the bill? If my earlier submissions are correct, the provisions in question will all become spent as a matter of course when the UK leaves the EU next March. On the known legal position, when the bill was introduced and passed, these constraints would cease to have practical legal effect at that time. And if confirmation is needed, the UK Act provides for the repeal of all of these provisions. So in my submission, it's clear the provisions will become spent as a matter of course. The only question is whether it's open to the Scottish Parliament to make the provisions in the bill to deal with that anticipated event. And what's important about these provisions is they don't come into force on royal assent, but require to be commenced by ministers. And ministers, and they can't and do not modify any provision unless and until they are brought into force. Ministers may not lawfully bring them into force until any provisions which are protected from modification are indeed spent.
You're not arguing that the section 1(2) postponement applies to this, because there's no incompatibility with
It's
EU
not an
law.
incompatibility. It's a question of protected enactments and modification.
Yes. So it all hinges on the power of ministers to postpone the entry into force of section 33 until they make a commencement order.
Yes, and indeed one might put it the other way around, that the provision has no effect, is not part of the law. It's on the statute book, but not part of the law unless and until commenced. If the court has paragraph 7 to Schedule 4 before it, that's at MS 547. Subpara 1, Part 1 of this schedule does not prevent an act of the Scottish Parliament restating the law or restating it with such modifications as are not prevented by that part, or repealing any spent enactment, or conferring power by subordinate legislation to do so. And one can perhaps approach the matter in this way. Once we leave the EU, in my submission, it would clearly be within the legislative competence of the Scottish Parliament to repeal these provisions if they had not been repealed by the UK Parliament. In the context of a regime making provision for the domestic legal consequences of withdrawal, in my submission, it would have been entirely legitimate to include an express power to ministers to repeal the specified enactments following exit day, relying on the last part of paragraph 7(1)(b), or conferring power by subordinate legislation to do so. And in my submission, that's essentially, that the matter of substance is what has happened. The provision has been enacted, but it cannot come into force until it is commenced, and ministers cannot commence it until the provisions are spent.
You say a power to repeal any spent enactment enables the Parliament to pass legislation repealing an enactment which is not spent, provided its entry into force is postponed until the provision will have become spent.
Yes, and of course I make the submission in a context where this is not a hypothetical question. You know, we can, as a matter of known legal fact, these provisions will become spent next March.
You're perhaps more confident of that than some people.
Perhaps at the point, perhaps all I can say is at the point when this bill was passed, simply looking to the terms of Article 50, unless something came along to change it.
Well, if something comes along, it'll never come into force. if the something is not leaving the EU.
If something comes along which changes the legal consequences that will otherwise flow next March, then the bill will no doubt would require to be amended. No doubt the UK Act would require to be amended.
But the relevant parts will never come into force, both because of the provisions of the legislation itself and because inconsistent legislation, if we don't leave the EU, is void.
Well, if you know, on the hypothesis that my Lord states, the point I make is when the bill is passed, we're not dealing with a hypothetical position. We're making provision for a known legal contingency. Under the last part of 7.1, in my submission, it would have been one could have envisaged a different provision in which the ministers were given an express power to deal with the matter following exit day. There could have been no objection to that in my submission. As a matter of substance, that's what we have. I recognise the observations of Lord Mance in the asbestos diseases case at MS 974, where he says that you judge what a legislature has done by what they've done and not what they might have done. But nevertheless, if the legislative technique which has been used is no different in substance from a technique which could have been used, then that may be helpful confirmation that what has been done is not objectionable. And I simply point again to the illustration that the Counsel General gives, which I mentioned a moment ago, that commencement powers may be used to effect a smooth transfer between regimes in contexts where, for the two regimes to have been in force at the same time would have raised a legislative competence question. Can I also make this point that the objection is that questions of legislative competence need to be determined before a bill has been enacted. In my submission, one has to look at different legislative competence questions as they arise in any given case. The question of whether a provision that relates to a reserved matter is plainly a question that can be asked regardless of any temporal contingency. The purpose and effect of a provision and whether that relates to a reserved matter in deciding that, the question of whether it's been commenced or not will often be irrelevant. And equally, in many circumstances, the question of whether a provision is incompatible with EU law or with convention rights may be answerable without regard to whether the provision is in force or not. But there are cases, and I say this is one, where one is making provision in anticipation of a known event, where it is, where one addresses the question of legislative competence at this stage, but one doesn't do so blind to the provisions that have been made for delaying the effect of the provisions to the point, to the known contingency. Can I turn then to the question of common law review? I have put before the court the question of whether this is properly within the scope of the reference procedure, and that's a matter for the court. However, it may be that the court could take the view that the theory upon which common law review arises is that there are implicit limits on the grant of legislative competence to the Parliament. That's the approach that my Lord Reid has taken in AXA, and also the approach the court has taken in relation to the European Communities Act. And it may be that if section 29, subsection 2 is not read as exclusive, then one can treat those implied limits as an aspect of legislative competence within subsection 1 of section 29, and therefore subject, capable of being dealt with within the context of a reference. If that is the analytical approach that one takes, then in my submission that emphasises the nature of cases which might invite a common law review.
The contrary argument is that AXA was all about the supervisory jurisdiction of the courts over statutory bodies.
Indeed.
And on that view, one might treat that as really being in a separate category from the type of review specifically confided to this court.
Yes.
Indeed, at the time when the legislation was first passed, it was the Judicial Committee of the Privy Council,
Yes.
which is defined in section 29.
It's not a decision. It's not a matter that's been decided. It's there. One can see our arguments both ways. The point I would make.
Obviously, this court has no, and even more so the Privy Council, wouldn't ordinarily exercise a supervisory jurisdiction over bodies in Scotland, except by way of an appeal.
Indeed. Indeed, and that's the argument the other way. The substantive point, if the court does feel that it can address the rule of law argument put up by my learned friend, the Advocate General, is that if the analytical approach is that there are implicit limits on a grant of plenary legislative competence, whether that be to the EU under the 1972 Act or to the devolved legislatures, that emphasises that such an analysis is invited only if the legislature in question were to enact legislation which is so contrary to the norms of constitutional democracy that it cannot have been taken to have been encompassed in the grant of plenary legislative competence. So I make the point really to emphasise the extraordinary nature of the case that would invite such a review. And indeed, one might take the view that legislation of the Scottish Parliament, which invited that question, would be legislation of a character such that, if it were enacted by the UK Parliament, would invite the court to address the issue left over by Lord Steyne at the end of his speech in Jackson.
And Lord Hope.
And indeed by Lord Hope. That's at MS 3199 to 3200. And in my short submission is on no view does this legislation fall into that category. Particularly when one bears in mind that one only gets to this proposition if the legislation is otherwise within the plenary legislative competence of the Parliament. And I recognise, of course, that the powers granted to ministers are wide, but that simply reflects the nature of the task, and they are not unconstrained. So Section 11, which I looked at a moment ago, is a power that may be exercised only if specified conditions are met, and indeed more stringent conditions than the equivalent power granted under the UK Act to ministers, because of the provisions of 11(1)b. In all of the powers provided in the Act, certain matters are specifically excluded. One can see Section 11, subsection 8 as an example. Each of them is subject to sunset provisions, Section 11, subsection 10. And importantly, they're all subject to scrutiny by the Scottish Parliament, both under the standing orders of the Parliament, which the Court has at tab 84, and also by reference to the specific provisions of the Act itself in Section 14. And there are requirements in the Act as regards the information to be provided with any regulations at section 16. The ministers to whom these powers are given are accountable to the Scottish Parliament, and whether it was appropriate to give ministers these powers and the terms in which they've been granted was quintessentially a matter of legislative judgment for the Parliament. My Lady and my Lords, I've dealt with all, I hope, all the points that have been taken in the original case. If I've missed anything, I hope it's covered in my written case. And therefore I should turn to the point with which the Advocate General started, namely the impact of the enactment of the 2018 Act on the Scottish Bill. And my first submission is that, for reasons I'll outline in a moment, the 2018 Act does not affect the legislative competence issues which the Court requires to address. It would be fair to say that my learned friend and I have perhaps passed each other, going in opposite directions on this. His initial position in his case was that one assesses competence as at the time the Parliament passed the bill. And I noted in my case that since the measure is only a bill and not yet an act, how can the court shut its eyes to changes in the law that have taken place in the interim? And in my submission, that is correct in relation to changes to EU law and convention rights. So if there were a change to EU law which affected legislative competence while a reference was pending, the court would require to give effect to that. But in my initial thoughts, I had failed to give proper effect to sections 30, subsection 5 and subsection 6 of the Scotland Act at MS 426. If the court has those provisions in front of it. Subsection 6 applies where any alteration is made, A, to the matters which are reserved matters, or to Schedule 4, whether by virtue of the making, revocation, or expiry of an order in council under this section, or otherwise. So any alteration to inter alia Schedule 4, and that's what we're concerned with here, where the effect of the alteration is that a provision of an Act of the Scottish Parliament ceases to be within the legislative competence of the Parliament. The provision does not for that reason cease to have effect, unless an enactment provides otherwise. And of course that final phrase forces the legislature to face up to the consequences of what it's doing if it's changing existing acts.
Yes, is that not concerned with what you've just said, existing acts?
Well, that was certainly, initially one sees that and one sees it relates to acts. Yes. But the answer to that, my Lord, is found in the question which the court is required to address in section 33.
Yes, but it's not yet an act.
But if my Lord goes to section 33,
yes.
The question is whether a bill or any provision of a bill would be within the legislative competence of the Parliament.
Yes, so one is looking forward to when it becomes an act.
Well, that's precisely the question.
Yes, because legislative competence is a concept that's only applicable to acts.
Well, indeed, and that's why when one reads the question or thinks about the question, one has to read into it something which, along the lines of, if the bill were an act, And the question is whether, and the question, and I suppose a question of interpretation, is whether if the bill were an act is read looking forward, anticipating, as my Lord says, or is read as at the time when the bill was passed. The short point, perhaps, to pick up on my Lord's point about the wording of subsection 5 and 6, is that once one appreciates that one has to read into section 33 that if it were an act, then the measure can have the benefit of section 30 as well as being read with section 29.
But don't the word ceases to be imply that subsection 6 is concerned with provisions which were at one time, provisions of an act which were formerly within legislative competence but have ceased to be because of the alteration in another law?
Well, I see the point, my Lord. I entirely accept that 6 is focused on existing acts, but my short point is once one appreciates that measures that are being considered under 33 need to be considered as if they were acts, then one gets the benefit of all, not only reading it with 29 and the limits on legislative competence, but potentially one may read with section 30, subsection 5 and 6.
But insofar as the 2018 Act affects the point is that we're not dealing with an act of the Scottish Parliament which would cease to be within legislative competence. We're dealing with a bill which would never become within legislative competence as soon as it became an act. That's the difficulty.
Well, precisely, my Lord. I entirely...
But it worse for you if that's right. It just means your first thoughts were better than your second thoughts.
Well, indeed, my Lord.
But I mean, what's as a matter of common sense, we should deal with the position as it is in the light of the UK Act. I mean,
well,
I can't see the point of not doing that.
Well, I suppose it depends on one's approach. The approach that looks to the point where the bill was passed does avoid what, frankly, in my submission, is an unattractive consequence, that the legislative competence rules by which the Scottish bill was assessed when it was passed by the Scottish Parliament might be changed while a reference is pending, and might be changed without Parliament facing up to the fact that that was what it was doing.
The difficulty, I mean, I think we're probably ad idem on this, is that legislative competence is defined by Section 29, and it applies only to an act.
Indeed.
And therefore, to speak of whether a bill was within legislative competence when it was passed is meaningless.
It's why, my Lord, one always has to, and this is perhaps the light bulb moment that struck me at the end of last week, courtesy of being shown the provision in the Government of Wales Act, it is that one always has to read, when one's looking at legislative competence, in advance of royal assent. At whatever stage, one is always having to ask if it were an act, because that's the only way one gets to section 29. And if that's correct, then my short submission, and it's either right or it's wrong, is that the last subsections of section 30 can be come into play, and at least permit the court to take the approach that the right point in time is when the bill is passed. And it does have, and in answer to my Lord Carnwath's point, rather depends on one's point of view, what makes common sense and what doesn't in the kind of situation that we're faced with. And I do make brief reference in my case to the Strand Greek Refineries case, and I recognise that there has been authority in the Privy Council that my Lord Sumption and my Lord Carnwath were involved in a case, Ferguson, 2016 UK PC2, which look at the common law analogue of that. But if I'm right on section 30, subsection 5 and subsection 6, I don't need to look at those issues. And if that's correct, then the legislative competence of the Parliament to pass the bill was not affected by the subsequent enactment of the UK Act, and it can pass to royal assent, and the questions of modification simply don't arise. I should perhaps just make one point about the Government of Wales Act, section 109, which prompted this thought. It's at MS 1628. 1628.
1628.
And it's
we were given it loose yesterday.
yes, and you also have, indeed, I think, I'm told it's in the same form. And it's subsection 5, any alteration, whether by virtue of and so on, does not affect the validity of an act of the Assembly passed before the alteration takes effect. Now, I accept the wording of that is different, and I accept my learned friend, the Advocate General's observation that the Government of Wales Act, like the Scotland Act, distinguishes between bills and acts. But if the court goes back to section 107 at 1626, the court will also see that at 107.2, the Government of Wales Act distinguishes between a bill being passed by the Assembly and receiving royal assent. So the use of the word passed in section 109.5a invites one to look at the passage of the bill rather than at the giving of royal assent. So the submission that I make would have the virtue, the other virtue perhaps, of enabling a consistent approach to be taken across the devolution statutes to this particular question. Can I say, if that's correct, the question of modification doesn't arise and all those submissions fall away? I, of course, have to recognise that issues may arise as to how the two acts fall to be read together, but those would not be issues of legislative competence. If I'm not correct in that submission, then I need to address the extent to which the Scottish Bill would, if it received royal assent, modify the UK Act. And I recognise, I think we all recognise, that's a wholly artificial question, because the Scottish Bill was passed now many months ago. It did not intend to modify the UK Bill, it could not do so. But the remainder of my submission is all predicated on the hypothesis that the court is required to address that hypothetical, that artificial question. May I first address the Advocate General's submission that the whole bill is out with legislative competence on the ground that it modifies the UK Act. That submission is methodologically unsound for two reasons. Firstly, because section 29 of the Scotland Act focuses on provisions. Section 29(1) tells us an act of the Scottish Parliament is not law so far as any provision of the act is outside the legislative competence of the Parliament. So one has, well, there is no help but to look provision by provision. And the second methodological flaw in my learned friend's submission is that the characterisation of the UK Act as a protected enactment does not result in the subject matter of that Act being a reserved field. And I've already made a submission about the distinction between the two forms of limit. The UK Parliament could have done that. It could have put the subject matter of the 2018 Act into Schedule 5, but it didn't do so. It included it as an enactment protected from modification. And that requires a forensic examination of the sort that I briefly discussed with my Lord Sumption earlier this morning.
Does provision have a defined meaning?
Does
Provision, I mean, how narrow or wide do you take it? Is every subsection or every subparagraph be looked at individually? Or could one say, take a chapter as being a provision? I mean, it does seem rather, if we have to go through line by line, we end up with a bit of a...
for reasons I'll be able to explain, it can be taken fairly efficiently. But in my submission, provision may be a section, it may be a subsection, it may be a group of sections. I accept that, but
Well, it doesn't signify for your essential argument, does it? Whether you take it as an individual subsection or a chapter. Your point is that the applicant's argument cannot be sustained because provision means something other than the entire legislative.
yes, there's no help but for looking in a relatively forensic way at the provisions of the bill and the question of whether they or any of them, and if so, which of them, modify provisions in the UK Act.
It's clear from the list of protected provisions that the word provision can cover an entire act or subsection. But I think the clue is in section 29.1, which tells us that the Act is not law so far as any provision of the Act is outside legislative competence. So that, I think, compels you to go through it line by line.
Indeed, and I accept that one can probably take a section rather than... But there may be cases where it's a particular subsection, which is the objectionable one. And on the other side, as I say, the protection of an enactment is not the protection of a field. So just because the UK Act makes provision in relation to the domestic law consequences of withdrawal from the EU and does so for all parts of the UK, it simply doesn't follow that the Scottish Parliament cannot make provision in relation to the domestic law consequences of withdrawal as long as it doesn't modify the UK Act. So, for example, the Scottish Parliament makes provision which has no analogue in the UK Act, then that does not modify it. And my learned friend, the Advocate General, accepts in his case a number of provisions, but a number of provisions have no analogue. And if I might just identify those which I say the Scottish Bill have no analogue in the UK Act. Those are section 12 at MS 219. Which deals with breaches of international obligations arising from withdrawal from the EU. Section 13 on the next page, which is a power to, what we call the keeping pace power, the power to make provision corresponding to EU law after exit date. And just in terms of the discussion I had with Lord Sumption earlier, it's perhaps worth reading that provision, the keeping pace power, along with section 19 of the UK Act, which the court will find at MS 708. Section 19 in the UK Act says, nothing in this Act shall prevent the United Kingdom from replicating in domestic law any EU law made on or after exit day. And Section 13 of the Scottish Bill is a provision which enables Scottish ministers within devolved competence to make provision corresponding to provisions in EU law having effect after exit day. The other three provisions, which are, as far as I can see, of no analogue and which have substantive effect, are sections 26A, section 36A, and section 36B of the bill, which contain a duty to consult in relation to environmental matters, a duty on ministers to report to the Parliament about how deficiencies have been addressed, and 36B, a duty to make arrangements for an evaluation of the effect of the Act and regulations on health and social care. In my submission, the simple proposition is there's no analogue in the UK Act. There's nothing in the UK Act that precludes the Scottish Parliament from making these provisions. They make provision for things the UK Act has simply not addressed. But my second general submission is that insofar as the Scottish Bill's provisions are materially identical to provisions in the UK Act, they don't modify it. The Advocate General talked in his submission about frustrating the intentions of the UK Act. I don't accept that that's a relevant approach. But in any event, it's hard to see how a provision which is materially identical frustrates the intention of the UK Act. And the Advocate General helpfully identifies in paragraph 21 of his supplementary case many provisions which he accepts are materially identical to provisions in the UK Act.
Although he also, in quite a few of those paragraphs, notes particular aspects of the provisions which he says do constitute modifications.
Yes. And I've addressed those shortly in my second supplementary case. And I'm content on those very particular points, subject only to a submission I'll make in a moment about section 11, to rest matters on the exchange of writing.
Sorry, the second supplementary case,
My second supplementary case, I seek to address the points taken by the Advocate General in his supplementary case. And I'm not sure if those are in the bundles, my lord. But I'm content, subject to a submission I'll make in a moment, simply to leave the points of detail that were picked up by the Advocate General to my responses in writing.
but you accept in principle that if you find you replicate a provision, but you add qualifications or conditions to it, that is a modification.
Well, I've sought to address each of the points made by the Advocate General in my second supplementary case. In my submission, it's dangerous, my lord, to speak in the abstract, or may be dangerous. I think one may have to look carefully at the provisions in question and put them side by side and ask, does this actually mean that the provision in the protected enactment is being modified? But Lord, I'm afraid there's no, that in my submission is the correct way to address the question. And the basis of the Schedule 4 protections that are given to protected enactment is designed to allow for the devolved Parliament to make provision within the same field as long as it doesn't modify. And that's not an unusual problem in the context of federal or quasi-federal systems. I've put in bundle one case from Canada, not because I rely on it, given the differences between our system and their system, but because it does illustrate the kind of question that can arise. And for a very particular comment by Mr. Justice Dixon, as he then was, which is at MS 3354, to the effect that duplication is not modification, and secondly, that a degree of untidiness is inherent, is perhaps the price one pays for having a multi-layered constitutional system.
Yeah, I just think of the practicalities.
Yes.
I mean, if we find that anything involves an impermissible modification, then in practical terms, the bill has to go back to the Scottish Parliament.
Yes.
And as long as we lay down reasonable guidelines as to what is permissible and what isn't, then it'd really be much better for the Parliament to do the job than for us to try and do it.
Indeed, but my Lord, just in terms of procedure, if this court were to find any part of the bill was not within legislative competence, it is then open to the Scottish Parliament under its standing orders to address the particular issues that the Parliament, that the court has identified, and plainly from the perspective of the Parliament, it's helpful for the Parliament to know, well, it needs to know which provisions have been identified as not within competence.
I can see it's helpful, but it might. I'm just wondering whether there's a middle way where we can lay down principles without going through every sort of sub-paragraph and saying, yes, that is, that isn't.
Well,
but the Parliament would be in rather an unenviable position if clearly there's room for a good deal of argument here between very well qualified lawyers on either side. And
well,
for us to give, I don't know, we might have to see, but for us to give sufficient guidance to deal with each individual provision might be even more troublesome than just biting the bullet.
Yes. I would like to, I made the observation yesterday that issues have become capable of being dealt with in a relatively focused way as a result of the exchange of written material. And I say that because if I'm right that a provision that has no analogue in the UK Act is within competence, one can readily identify those. If I'm right that a provision that is materially identical is within competence, my learned friend, the Advocate General, has identified those subject to particular points, which I think I've addressed in my second supplementary. I will check, my Lord, if I may, after today, whether there is any loose end there, but I think I've addressed those, and I'd be content to leave the matters in the short way that they've been dealt with.
We have to deal with it provision by provision, do we not? Because the Section 33 provides that the question referred to us may be whether a bill or any provision of a bill would be within competence. And the reference that we have received says both that the bill as a whole is outside competence and that certain individual provisions are.
Indeed.
So I don't see how, without going through the latter, we can possibly deal with the reference.
Regrettably, I think from the court's perspective, but perhaps thankfully from the Parliament's perspective, in my submission that is correct. And one has to bear in mind that this is a bill that has been passed by the Parliament. It's been held back from royal assent by the reference because it is said that provisions are not within legislative competence. In my submission, looking to the nature of the reference, the court really does have to say whether particular provisions are or are not, if one can't deal with the matter as a general, in a more general way.
Strictly speaking, because the issue you're now discussing arose relatively recently when the UK Act was passed, it's not the subject of specific questions in the reference. And you argue that we shouldn't deal with it at all. But if we do, presumably you would rather avoid the risk of the possibility that matters might have to come back here again.
Well, indeed, my lord, absolutely, and that's one of the reasons for clarity. And just to be clear, I make my submission in relation to subsections 5 and 6 of section 30. In my submission is a matter of substance and not simply what may procedurally be dealt with within the reference. In the Advocate General's supplementary case, I think there was a suggestion that the court might treat the reference as limited to the grounds upon which he's presented the questions. In my submission, that wouldn't be correct. If once the bill or a provision is before the court and there is relevant law that needs to be looked at, the court certainly can, and in my submission should, look at relevant law. And apart from that, it would be unsatisfactory to have a situation in which the court limited itself to the grounds on which the questions have been presented, but left this enormous loose end over, held the bill was within competence or partially within competence, if that was what the court came to, but left over the very serious question that the Advocate General has presented in terms of whether the whole bill has gone as a result of the way in which the UK Act has come into force. The relevant standing order of the Parliament, just to pick up on my conversation with my Lord Carnworth, is at MS 3992, and it's Rule 9.9.4, which makes clear that amendments are only admissible when a bill is being reconsidered following a decision of this court for the purpose of resolving the problem which is the subject of the reference or which is the subject of the decision of the Supreme Court. So one would have the further unsatisfactory, if one didn't address the question, but only the grounds on which the reference came to this court, one would have the highly unsatisfactory position that the Parliament would, under its standing orders, not be able to address these additional matters unless the court has addressed them. And one would then inevitably have to consider a further procedure. So if I might just make a final point in support of the proposition that duplication is not modification, and that's to refer again to paragraph 7 of Schedule 4 at MS 547, which explicitly states that the Scottish Parliament, nothing in Part 1 of that schedule prevents an act of the Scottish Parliament from restating the law. The Advocate General's submission that the intention of Parliament was to create a single regime for the UK, in my submission, falls down when one appreciates the protection that the 2018 Act has given itself is from modification. It hasn't sought to give itself greater protection. And his very broad submission that basically sweeps aside any potential for the Scottish Parliament to legislate falls down, not least because the Scottish Parliament is not prevented from restating or from making additional provision in the context of a restatement with such modifications as are not prevented by Part 1. So I've dealt with provisions where there's no analogue. I've dealt with provisions that are materially identical. I, for my part, accept that provisions which are referred to in my supplementary case would modify the UK Act, if that's a question that the court has to address. And the Advocate General agrees with me in paragraph 13 of his supplementary case.
These are the ones that are listed in
it's a very short supplementary case, simply
Paragraph 3.
identifying provisions which I accept would be affected by.
Is this your third supplementary case?
No, it was my original supplementary case, which I think is simply called supplementary case. And it's what...
It's paragraph 3.
Yes, and it's provisions such as the provision that the court looked at with my learned friend, providing for accrued Frankovich damages claims, the charter and such like. I should though perhaps make a particular point about the charter and why, what it is I'm saying in relation to modification. If the court has before it section 5 of the Scottish Bill at MS 213.
Just give that MS number again, please.
MS 213.
213.
And section 5 of the UK Act at MS 690. Sorry, my lords, I've given the wrong reference, and I'll get it in a moment. I was really just
213 is certainly right.
Sorry.
213 is certainly right.
213 is right, and it's just to find the provision in the... Oh yes, sorry, it's 5 subsection 4 in the UK Act at 690. And the UK Act at 5 subsection 4 says the Charter of Fundamental Rights is not part of domestic law on or after exit day. And at 5 subsection 1 of the Scottish Bill, it says, reading short, the Charter of Fundamental Rights are part of Scots law on or after exit day with certain qualifications. In my submission, it's a modification, but the important point, it's a modification because both provisions are dealing with, specifically with the situation on or after exit day in the context of the continuity of law.
Is the effect of section 5.1 of the Scottish Bill to incorporate the Charter of Fundamental Rights as part of Scottish law on an ambulatory basis, i.e. subsequent amendments to it would be given effect in Scotland, or does it simply incorporate the Charter of Fundamental Rights as it stands at the point of exit?
5.1 is subject to the qualifications in A and B.
Well, I don't think that's, I think, concerned with a different point, isn't it? That it is, so far as the Charter has effect in EU law before exit day, it's going to have effect in Scottish law after exit day. But that is consistent with either possible view that it's ambulatory or that it isn't.
I take the Lord's point. I think I won't, if my Lord doesn't mind, I won't answer my Lord now, but hopefully we'll be able to answer him before the end of the day. The short point that I would like to make there, and it's just to make clear the limits of what I'm saying, is that this would not prevent the Scottish Parliament from enacting for non-reserved matters specific substantive rights which appear in the Charter in the future. I accept it's a modification because of the very specific nature and terminology. We already have, for example, in section 186 of the Children's Hearing Scotland Act 2011, a provision for consent to medical treatment by children, which is a reflection of Article 3.2a of the Charter. And the court may be aware that the question of domestic implementation of international human rights instruments in Scotland, other than the ECHR, is a live matter. So I simply, I think it's important that I am clear about the limits of what I'm accepting in relation to...
You're only accepting that there's an inconsistency so far as the Charter of Fundamental Rights is treated as the source of the relevant right.
Well,
You're not accepting it as applied to the subject matter
Indeed.
of the Charter. So that on that point you differ.
Indeed, and likewise, and my learned friend, when he said, could the Scottish Parliament enact its own Human Rights Act? Well, paragraph 7 does say that the Scottish Parliament may restate the law with such modifications as are open.
It can also add to the number of human rights.
Well, indeed.
Drawing on whatever sources it thinks fit.
Indeed. So I think it's important I make those points given some of the submissions that my learned friend, the Advocate General, has made. Of the specific points made in the Advocate General's case on which we differ, the most important point of contention is in relation to Section 11, the fixing power. The UK Act in Section 8 provides a fixing power, and under Schedule 2 it is open to the devolved administrations to exercise that power. And my short submission is that the grant of a power in a protected enactment, first of all, one can't say simply as an abstract matter that the grant of a parallel power, which is in different terms, is necessarily a modification. And one therefore has to look carefully at the provisions in question. And the power under Section 11 is narrower in certain respects and subject to additional requirements. First of all, the grounds for its exercise are more tightly confined than the grounds for the exercise of the power under Section 8 of the UK Act. In particular, there's a requirement for of necessity under the Scottish Bill. It may be helpful to have the provisions in front of one. Section 11 we looked at a moment ago, which is at MS 217. And the provision in the UK Act is Section 8 at MS 694, made available to the devolved administrations under Schedule 2.
Yes, what's the provision in Schedule 2 then?
Schedule 2 is at MS 719, paragraph 1. A devolved authority may by regulations make such provision as the devolved authority considers appropriate. That's the provision that we're looking at.
But then there are, the Advocate General's point is that there are restrictions placed upon that by paragraph 3.1 and also 14.1.
I'll deal with that immediately. Paragraph 14 is not relevant because it's concerned with regulations implementing the withdrawal agreement. And Section 11.8F of the Scottish Bill tells us that regulations under that provision may not be made to implement the UK withdrawal agreement. So paragraph 14 of Schedule 2 is simply doesn't arise in connection with Section 11. So far as paragraph 3 is concerned, the Advocate General's focused on subparagraph 1. No provision may be made so far as it modifies certain legislation and would, when made, be in breach of the restriction in Section 30A of the Scotland Act if the provision were made in an Act of the Scottish Parliament. And Section 30A is the provision in Section 12 at MS 698, which empowers ministers to, by subordinate legislation, to limit the power of the Scottish Parliament. And I should say no such regulations have yet been made. So at the moment, that doesn't arise. But the short point is this, that the Section 11 power at 11.5 says regulations under subsection 1 may make any provision that could be made by an act of the Scottish Parliament. So if the powers of the Scottish Parliament are limited, then that reads through to Section 11. And under paragraph 3.1b2, in breach of the restriction in section 57.4 of the Act of 1998, that's a provision that's added by that's a provision which the court will find at MS 734. And it's a power inserted into the, or a provision inserted to be inserted into the Scotland Act, that a member of the Scottish Government has no power to make, confirm or approve any subordinate legislation so far as it, among other things, is of a description specified in regulations made by a Minister of the Crown. So if regulations were made under that provision, that too would limit the power under Section 11. So the issues which concern the Advocate General in my submission fall away, because they're both the limits under paragraph 3.1 are limits which, if they were to come into effect by the making of regulations, would constrain the exercise of the power under Section 11.
And your position is that Section 11 of the bill is not wide enough to cover regulations concerned with the withdrawal agreement.
It's in terms, my lord. If my lord goes to MS 219,
Yep.
little f,
Oh, yes, thank you.
but regulations under subsection 1 may not be made to implement the UK withdrawal agreement.
That's
So
very-
paragraph 14 is, it doesn't arise.
Thank you very much.
And paragraph 3.1, as I say, doesn't arise for the reasons I've just outlined. I was going to, I'm making a very, I hope, short submission that the power in paragraph 1 is, in some respects, narrower. The court can see that it's actually the test for the application of the power in 11.1 is more restrictive than the test in paragraph 1 of Schedule 2. The extended application yes. The court will see, this is why Section 8 is relevant. If the court has if I'm in the UK Act, paragraph 1 of Schedule 2, if the court looks at 720, the court will see that the power given to devolved authorities under that provision incorporates the various provisions of Section 8. And additional limits on the power in Section 11, subsections 11.7 D, E, and G, which are constraints which prevent regulations being made, among other things, to remove protections relating to the independence of judicial decision-making, conferring functions on Scottish public authorities not consistent with its objectives and modifying certain matters. Those don't appear in Section 8. On the other hand, there are provisions at 8.7 or F and G which are not replicated explicitly in Section 11, but which could not be done under Section 11 by virtue of Section 11, subsection 5. And there's a specific requirement in the Scottish Bill at 13b to have regard to guiding principles of environment and animal welfare, which is no equivalent in the UK Act. So I say it's a power which is different in certain respects, narrower rather than broader, which is subject to the particular limitations which concern the Advocate General. And
I'm sorry, just check. The point made by the Advocate General in paragraph 19 of his supplementary case is that there's no restriction in the Scottish legislation corresponding to the restriction imposed by Section 12 of the UK Act,
yes,
which inserts Section 30A. And your point is that Section 57 of the Scotland Act is amended so as to impose that restriction. Although it doesn't appear in the Scottish Bill, but it's imposed by the 2018 Act itself.
I have a simpler point, which if my Lord goes to subsection 5 of section 11 in the Scottish Bill.
Yes.
Yeah. If an act of the Scottish Parliament couldn't be made, then the regulation-making power can't be used.
Yes.
So my Lord may well be right that there's another route to the point, but that's that's the basic point, that the power doesn't extend. There is one provision in the UK Act which doesn't have a yes. If I draw the Court's attention to paragraph 4 of Schedule 2, MS 722, no regulations may be made under this part by a devolved authority acting alone, so far as the regulations are to come into force before exit day or to remove arrangements of the kind described, unless the regulations are to that extent made after consulting with the Secretary of State. And there's no equivalent provision in the Scottish Bill. It's not a point the Advocate General's made, but it's right that I draw the Court's attention to that. And my short submission is this, that if the Scottish ministers want to use the somewhat broader powers in the UK Act than in the circumstances described, then they plainly need to consult. But if they don't require or choose not to use those broader powers, then the existence of a parallel power in narrower terms and subject to the competence limits that concern the Advocate General doesn't modify the equivalent provision in the UK Act. They effectively can sit together on the statute book. My Lady, my Lords, unless there are other matters that I can assist the Court with, or matters that I could elaborate on, I'm content to leave my oral submissions there, and to simply invite the Court to declare that the Scottish Bill was and is within the legislative competence of the Scottish Parliament.
Thank you very much indeed, Lord Advocate. Mr. Muir.
My Lady, my Lords, I'm here for the Welsh. I want to start by some submissions which take as their reference point Section 12 of the United Kingdom Act. That's in Volume 1 at tab 3, and the relevant provision, section 12, starts at page 697. There are at least 3 things that this is quite helpful for in my submission. But starting with what section 12 is doing, bottom of 697, top of 698, it's amending the devolution legislation. It does it first for Scotland by inserting a section 30 capital A, and then there's the equivalent provision for Wales and then Northern Ireland. It is addressing the post-exit day statute book, inter alia, because it's talking about retained EU law and modifying retained EU law. Retained EU law is that which is going to continue post-exit day. It's addressing that topic through a new restriction. 30A1, cannot modify so far as. And that new restriction is a part restriction. I say a part restriction because it is triggered by the making of regulations by a Minister of the Crown, insofar as the modification is of a description specified in regulations made by a Minister of the Crown. No regulations, no restriction. It's also a part restriction because even if there are triggering regulations by a Minister of the Crown, you, that's the Scottish Parliament or other devolved legislature, can make a modification under 30A2 if immediately before exit day it would have been within competence. So it would be EU compatible on the day before, even if regulations are made. That's the design of it. And that new restriction takes the place of the old must act compatibly with EU law, section 29(2)d. You'll see that on the previous page in section 12, subsection 1. It's the same for Wales and the same for Northern Ireland. The other competency restrictions remain. So the legislature cannot legislate in a way which relates to a reserved matter, including international relations. Why do I say that's illuminating to test the logic that you've heard from the Advocate General? 3 questions. Firstly, do previously EU-occupied fields revert to the United Kingdom Parliament after withdrawal? And that's their position. It was his 5th of 6 points in relation to international relations. And it's very strikingly described in paragraph 44 of their printed case at page 58. As he put it yesterday, competencies will go back to the United Kingdom Parliament upon withdrawal. He said the starting point cannot be that legislative competence includes areas governed by EU law. And you'll find the written submission at page 58, paragraph 44. That clashes with this entirely. This is not an empowering provision. It's a new restriction. There is no conferral of competence upon any of our legislatures by the United Kingdom Parliament in order to be able to act within the fields previously occupied by EU law. Why? Because they didn't need to be. We have the competence within those fields. What has changed is that the United Kingdom Parliament can impose a new restriction. And as my Lord Hodge has put to everybody else, that's Miller, paragraph 130. That's the difference that it makes. But is there a baseline starting point that we have competence, absolutely, and it's reflected very, very clearly in this provision. Now, we picked them up on this because the original Annex C in the applicant's written case claimed that there was a conferral of competence in the United Kingdom Bill, at the time Clause 15. I'll just give you the references. Pages 91 and 92 is the paragraph 6 and 7 of their Annex C. We picked the point up at page 165 and 168. There's no conferral of competence. The baseline is there's already competence. This is not an empowering provision and never was. Paragraph 2.3 and 8.1 of our case 165 and 168. And they've withdrawn the point because Annex C, as amended in the supplementary case of the appellants, not in the electronic bundle, but page 13 internally of that document, paragraph 8 internally of that document, takes away what was previously claimed. We are conferring competence. You're not conferring competence. You don't need to confer competence, precisely because the competencies don't go back to the United Kingdom Parliament. They are where they always were, within the non-reserved matters, with the devolved legislatures. Now, those section 30A1 regulations are important because it is only if a Minister of the Crown, after a very elaborate procedure that is collaborative, looking down the rest of page 698, makes those regulations, that the restriction then bites. And behind the scenes, but very importantly, is an intergovernmental agreement that my clients have signed up to. It's volume 10 at tab 89, and the relevant pages to just get the feel for it are 4027 paragraph 5 and 4029 paragraph 3. And what the intergovernmental agreement explains is that it is envisaged that there will be some areas where after this collaborative process, it will be recognised as appropriate to have a framework, at least in the short term, for the United Kingdom as a whole. And you'll see from page 4027, read with 4029, that what's envisaged is 24 areas out of 153, or for Wales, 26 areas out of 153, but all to be the subject of this collaborative process, and then regulations to be made. So that's the context for if you have regulations that are made by a Minister of the Crown after this process, then in those areas, the consequence will be there will be a restriction, but you'll still be allowed to act consistently with 30A, sub-paragraph 2. So the first question it illuminates is the one about reversion to the United Kingdom Parliament. No, wrong, and the structure of this section shows that the United Kingdom Parliament also understands that, although the Advocate General disputes it. Second question that it illuminates, is it really correct that to legislate for post-exit day statute books for Wales, Scotland or Northern Ireland relates to the reserved matter of international relations? We say no. It's paragraphs 10 to 12 of our case at pages 171 to 174. That's an extravagant claim, and it has very alarming logical implications. Take this very provision. This is recognising that you, the devolved legislatures, will be making legislative provision for the consequences of withdrawal in the sense of the post-exit day statute books for Wales, Scotland and Northern Ireland. And you'll be doing that with a free hand, absent regulations in those areas where no regulations come into being, and you'll be doing it with a less free hand in an area where there are regulations, because then you'll have to comply with 30A, subparagraph 2. That fails immediately if the submission is correct that legislation dealing with the statute book post-withdrawal is legislation that relates to international relations for the purposes of Schedule 5, paragraph 7. And it fails because that competency restriction remains. See section 12, subsection 1. And it remains for Scotland and the other devolved legislatures. So if it really were right that to do that, to legislate for the post-exit day statute book, is something that relates to international relations, none of this is going to work. Again, this proceeds on the basis, correctly, that the international relations reserved matter and the test for relates to do not have the expansive meaning that you have heard contended for at this hearing. So it's wrong, and it's illuminated as being wrong and incoherent. And of course 7.2 wouldn't help. 7.2 will not save you in relation to legislation of that kind. So take an area, there's no regulations, free hand, you go ahead, legislate for the statute book. It's post-exit day, so it can't be something that you're doing to implement EU law. EU law doesn't apply in Wales after exit day, nor will it be something that you're doing to implement some international agreement. So it tests to destruction the logic of this expansive meaning of international relations, and it's very important that it does, because otherwise these arrangements are not going to work, and they will have been defeated by the argument you've heard. Indeed, the logic of it, and you heard it yesterday, went as follows. Withdrawal from the EU is something that relates to international relations. The post-withdrawal statute book is something that relates to withdrawal. It relates to withdrawal because it's dealing with the consequences of withdrawal. Therefore, goes the loop, that must be something that relates to international relations. And it just breaks down at every step. Even if withdrawal is something that relates to, it doesn't follow that the consequences of withdrawal for the statute book is something that relates to international relations. Not relates to withdrawal, relates to international relations. And so it breaks down. It also breaks down if you go to step 1 in the rule book in relation to the meaning of relates to, loose or consequential. Loose or consequential. It's fatal if it's either loose or consequential. The logic of the argument is it's consequential. It, says the Advocate General, is legislating for the consequences of something that relates to international relations.
If a further act of the UK Parliament were necessary in order to give effect to an agreement reached with the EU, would that legislation or corresponding legislation by the Scottish Parliament relate to international relations?
I wouldn't accept that it does. And I'll show you a human rights example.
So you would submit that legislation to give effect to an international agreement doesn't relate to international relations?
Correct.
I see.
While we've got the legislation, it might be worth just taking a couple of examples that you perhaps haven't looked at yet. In section 17 of the United Kingdom Act, page 707, you'll find an interesting provision from Westminster, and it reads at page 707, section 17(1), a minister of the Crown must seek to negotiate on behalf of the United Kingdom an agreement with the EU. And if you supposed that the Scottish Parliament had included within their bill, which they didn't, a provision that said a Scottish minister must seek to negotiate on behalf of Scotland an agreement with the EU. And you can say a similar thing over the page at 708, section 18. A Minister of the Crown must lay before each House of Parliament a statement in writing outlining the steps taken by Her Majesty's Government in negotiations under Article 52 of the Treaty of the European Union. So you can see examples where you would see that the relation to international relations as a reserved matter would be engaged.
So is it your submission that the only legislation of the Scottish Parliament within the reservation for international relations is legislation which would require the Scottish Parliament to perform diplomatic functions?
No, I'm not going that far.
Can you give me any example other than that?
Let me reflect and come up with an example. The submission I want to make is that legislating for the post-exit day statute book does not relate to international. That's my submission, my positive submission. I'm giving you some examples that clearly do. I'm not making the submission that there's nothing else. And I do accept that one could have a matter relating to international relations which would involve giving effect to an international obligation. Of course I accept that, because that's what explains paragraph 7.2 of Schedule 5. But if I may, let me park that one and see if I can give you examples that are closer to the line. You've got something which is very distant from the line, and I've given you two things that are within it. And for now, that's how I'm going to leave it. Question 3, is it contrary to the rule of law to legislate now, pre-exit day, for the post-exit day statute book? Contrary to the rule of law, uncertain. UK Parliament can do it, says the Advocate General. Scots and Welsh and Northern Irish legislatures would not be able to do that because of an artificial approach, he says, you take when you are looking at a bill. Again, this provision helps you with that. Of course, it must be the same for everyone. The rule of law and those core values of the Constitution apply to the United Kingdom Parliament. But in any event, here's an example that on its face is recognising that a devolved legislature can perfectly properly legislate now for the statute book consequences post-exit day. And just on that, can I just go back to this tax example because of the point that was made about temporal powers and commencement powers? Because we say it is quite a helpful example, potentially. It's at page 175 in our written case, and it is an example where the Welsh Assembly left to a commencement power of the Welsh ministers the securing of avoiding double taxation. And we tell the story at page 175 in the printed case. But can I just give you, please, the references? So the Wales Act of 2014 at page 2222 had provided, so United Kingdom Parliament had provided that the UK's landfill tax was going to be switched off at a date that the Treasury were going to appoint. They had, in the same statute, provided for a devolved tax, a Welsh landfill tax, to take its place. And that tax is provided for by inserting a section into the Government of Wales Act. And you find all of that at pages 2221 and 2222. The Welsh Assembly then legislates to bring in the new Welsh landfill tax in the Act that is enacted, Volume 6, at tab 28, which was the equivalent the relevant Tax Collection Act for the new devolved legislation. It makes clear that the commencement is for ministers by means of a commencement order. Double taxation would have been incompatible with the Wales Act 2014 because you couldn't collect tax number 2 until after you'd switched off tax number 1. That engages Article 1 of the first protocol because it's double taxation. So you could have had a reference, you could have had a question of competency coming before this court in relation to that legislation when the point would have been, well, here you are, you've provided for this new tax, you haven't said when it's going to come into force, you've conferred a power and you're leaving that to ministers. In theory, the tax, the switching off of the old tax could have been repealed. In theory, the Treasury might never have switched it off. Is there any problem with competency? Absolutely not, because by design, it has been dealt with. You judge the Welsh Assembly on the basis of what they have enacted, but what they have enacted includes the commencement power, and sure enough, the Welsh ministers make their commencement order at volume 6, tab 32, page 2758, on the date that coincides with the Treasury switching off the old tax. So can you legislate properly in anticipation? Can you take into account contingency? This will only come into effect when there's a commencement order. Power conferred on ministers, and the temporal coincidence that avoids the human rights incompatibility that would give you the competence problem, because incompatible with the Human Rights Act. The answer is yes, and we submit that that's quite a helpful illustration that the court may wish to consider. Footnote to that point. The Advocate General submitted yesterday, and he submits in his case at paragraph 71, page 67, that this is somehow contraindicated by a comment in Christian Institute at paragraph 109. I'm not going to go there, but if you do go there, you'll see it's dealing with a completely different point. It's volume 7, tab 35, it's pages 2849 to 2850, and it was dealing with what was inherently an Article 8 incompatibility. This enactment will be incompatible with Article 8. We are going to say so, even though it's not yet been brought into force. It doesn't go anywhere near the issue of whether a differently designed legislation could secure its competence and compatibility by contingency and by temporality. Those are the 3 points I wanted to get out of that reference point provision. And subject to the point to come back to, may I add these brief submissions. Human rights and the Human Rights Act. And you heard the submission yesterday. Human Rights Act is intended to be a single, unitary, United Kingdom-wide human rights scheme. We can't accept that is what the Human Rights Act does, or the consequence that it has. In fact, the Human Rights Act is quite a helpful illustration of duplication. This court will have encountered provisions in extradition and immigration legislation that says you can't extradite if it would be incompatible with someone's convention rights. You can't deport if it would be incompatible with someone's convention rights. That, in fact, is occupying the same ground as Human Rights Act Section 6. It's telling you something that you already know, because a public authority can't act incompatibly with convention rights. It doesn't mean there's any inconsistency, and there's certainly nothing in the Human Rights Act that would preclude that. Second point, the Human Rights Act has never prevented other rights being enacted or protected. It's never prevented more generous rights. It specifically recognised that it wasn't cutting down on existing rights or rights provided for in other law in Section 11 of the Human Rights Act, page 1231, volume 3, tab 17. So take an example. If you had a provision which guaranteed due process even for cases where you are not determining a civil right or obligation. That would go beyond Article 6, because Article 6 gives due process rights for decisions which are determining a civil right or obligation. In fact, the Charter is a good example of that because it does that for due process. Now, if you had a legislative provision, including within a competency area by a devolved legislature, there would be no conflict with the Human Rights Act. And that's why you can have equalities legislation. It doesn't conflict with Article 14 just because it's more protective than Article 14. And in the context of Wales and the Welsh Assembly, I hope you've got, and I only give it to you as illustrative, that we've got an example in the human rights world in the form of the Welsh instrument. It's the Rights of Children and Young Persons Wales Measure of 2011, giving effect to the rights and obligations from the United Nations Convention on the Rights of the Child for Wales, something that hasn't been done for England, and something that can perfectly properly be done without any clash or frustration of the Human Rights Act, because the claim that's made for the Human Rights Act is extravagant with respect and wrong. So far as repeal is concerned, you know that Schedule 4, Paragraph 1 of the Scotland Act tells you if it's a protected enactment you can't modify, and Section 126 tells you modify includes repeal. Ergo, could you repeal if it's not protected? Yes. The example that's closest that this court has had of a head-on collision in Wales was the Agriculture Sector Act. It's Volume 7, Paragraph 40. Statutory abolition of any board for agriculture in the Westminster 2013 Act for Wales. Welsh Assembly Bill retains a board for the agricultural sector for Wales because of the disagreement between the two legislatures, and this court upheld the Welsh Assembly Act on that occasion. Modification and inconsistency. I've just got one submission to make in relation to that, and it's about adding mandatory preconditions. I agree with what was said a few minutes ago. Don't address the issue in the abstract, but just to be clear, so far as our position is concerned, we don't accept that the adding of a mandatory precondition would constitute a modification to a protected provision or enactment. As a matter of principle, you'd have to look at the particular case and the particular implications. But can I just give an example? Suppose the United Kingdom Act deals with a particular decision-making process, and let's suppose it says there needs to be consultation before a decision of a particular kind is taken. It's not a reserved matter, but it's a UK piece of legislation that includes Wales or Scotland and Northern Ireland within it. Suppose the Welsh Assembly said consultation papers that are issued in Wales need to be provided both in English and in Welsh as a precondition. Now it would add, and you've got examples in the case law, adding a crime doesn't mean you're modifying the criminal law. It would add, and it could add a precondition. It would, in my submission, be a good example of something that's entirely proper, benign, and competent, because it's not inconsistent. There's no clash between the two.
An example which is purely procedural.
Yes, I have. But all right, next.
How useful is that as an analogy?
I'm giving an example to address the question of whether adding a mandatory precondition means that there's a modification as a matter of principle. That's the question I'm addressing. I'm saying no to that question of principle. That's the example I give. But let's suppose the next provision said, and any decision made in the planning context for Wales is not valid unless the consultation has been translated into Wales. That would be substantive in my submission. That would be equally competent and coherent. You're looking for a clash or an inconsistency, and to find a clash, you'd need the United Kingdom Parliament to have said, and the consultation paper shall only be in English. Or the United Kingdom Parliament to have said, and no requirement as to language in the consultation paper shall vitiate any planning decision reached as a result. Now, there should be no surprise to any of this, we submit, because after all, the common law can say, well, Parliament hasn't said you must consult, but you must consult, or you mustn't give someone a hearing. Why? Because fairness requires it. Are you modifying the statute when the court says that? Is there a clash or inconsistency when the court says that? No, you're identifying something which is external and important, but doesn't constitute a modification. The Government of Wales Act and the point of substance about when a new United Kingdom Act bites on a Welsh Act you have just seen. And I don't want to say anything more in relation to that. We drew it to your attention because it's very clear that whenever the Welsh bill becomes an act in that situation, it will have been passed at a particular date, and that's something that's governed by the Government of Wales Act, and Parliament has been very clear that unless you spell it out, you cannot impact on an act which had been passed at the time when the United Kingdom Act came into effect. That's section 109 at subsection 5. Would is because you're talking about a bill, you're scrutinising a bill, and it's acts that have competence. So you ask the question, would this bill as an act be incompetent? That's the reason why the word would is used in the legislation. Finally, our written case, I adopt. I include in that adoption the adoption of the 2 points about constitutional uncertainty. First of all, we do not accept that it is within your jurisdiction on a Section 30 reference to consider constitutional values that might found a judicial review. We've explained why in our written case at pages 177 to 178. It's because as a matter of substance, the source of those constitutional values is not the legislation that you've got before you. That's why there's the link to Jackson and primary legislation of the United Kingdom Parliament. It is something external. True, you read broad words as being limited by constitutional values. That's the principle of legality. It's referred to in AXA. But there again, the constitutional value we submit is external. That's why it would bite on the exercise of a prerogative power. That's why it would bite on the exercise of non-statutory powers. And secondly, we make the point that even if you take the rather innocent-looking local bylaws and planning conditions, page 179, as exemplars for uncertainty as a constitutional value applied to primary legislation of a devolved legislature, which is a massive leap. But even if you do, that's enough. Because when you look at the test in our paragraph 17.3, page 179 of the bundle, of what you need, even in a bylaw or planning condition, to find such uncertainty or unworkability as to conclude that there is unlawfulness. This case is not within a mile of it. And therefore, we respectfully submit, leaving aside whether it's within the jurisdiction, it's not a test that is even approached, still less infringed. I think I've actually said more about it than the Advocate General did yesterday. He didn't explain why that principle is infringed in this case. It wouldn't have been infringed in the case of the Welsh tax legislation. And if that's the height of the threshold and the pragmatism of the test in the bylaw context, it's impossible to see why there should be a lower threshold in the present context. That, my lady and my lords, subject to whether I can do better getting closer to the difficult line in terms of international relations, I say, as you have heard, that we are well away from it in this case. But subject to that, those are the submissions that I wish to make orally, in addition to our written submissions, on behalf of the Counsel General for Wales.
Thank you very much indeed, Mr. Fordham. Well, we will allow you to get to your feet with an example.
Thank you.
At 2 o'clock, should you have found one.
Yes.
But if you haven't, you won't.
Yes. Thank you.
Good. Well, we'll adjourn now and resume at 2 o'clock.